So again, we have Christy Granger going to present to you all today. And so without further ado, Christy, if you'd like to go ahead and take it over and get your slides pulled up, we would definitely like to hear what you have to say to them.
All right, sounds good. Good morning, everyone. I'm gonna see if everyone see that? Okay, great. All right, like Devon said, my name's Christy. I am the Court and Community Liaison Coordinator at CEICMH in Lansing. And we're going to talk today about how to build relationships with the prosecutor's office and the local courts. As we all know, it's all about relationships, right? If we don't have effective relationships, it's very hard to do the work that we do. So we're going to talk about what are the benefits of these relationships. One is it's going to foster collaboration. It allows us to share our resources, to improve overall community, and then, of course, to draw on one another's expertise. With that being said, as we know, some of the relationships can start off very rocky. They can create tension, some frustration, a lot of blame, finger pointing. And most of it comes from a lack of understanding of each other's roles and abilities within the law and the mental health code. So what I want to do is kind of tell you a little bit about what happened with us at CMH and how we got to the point that we're at. And at the end of this presentation, you can ask specific questions about that. And then we'll also talk to you about where we're at now. So for us, it was about 8 years ago. We, of course, did not have a court team. Each case management team managed their own court orders, what have you, AOTs. And so you'd go to court, each case manager. It was just very chaotic. At one point, things were not getting done, such as 6-month reviews. And our court required, as per the mental health code, that all 6-month reviews get done. Our judge, they kept a tracker of that and were noticing that these 6-month reviews were not getting done. With that being said, he sent a memo and they still weren't getting done, right? And he was like, this is part of the code, what have you. And at that point, he had a very negative view of CMH, felt like we were just disregarding all of his orders, what have you. And he actually fined our local CMH thousands of dollars. And in addition, threatened to put 3 of our administration members into jail for contempt of court. With that being said, of course, when money talks, right, and the threat of administration going to jail, things are going to change. And that's where it came out that we need to do something different at CMH, not only to track all of these things, but we also to build our relationship, right? Because if we don't have the backing of the court, the prosecutors, what have you, we're not going to get anywhere. So that's where my team started out. What ended up happening was, as we were working through this process, you know, we had several meetings with the judge and he just could not understand where CMH was coming from. So the educational piece of this, right? He's like, you just should be able to know where all of these people are and they should all be in treatment. And why aren't they getting followed? And why are they coming back to the hospital? Why are they coming before me? And so one day I just, you know, I always say, put my big girl pants on because this judge is pretty intimidating. I just said, Your Honor, can we just talk for a minute about this? He goes, whatever, Miss Granger. So we sat down and we chatted. And I finally explained to him and that, you know, he himself has private insurance, right? And if maybe he had an established therapist in the community and that he had built that bond with that therapist. And he went to the hospital and he came out and he was on a court order. And the court order said, you have to follow up with CMH because it was a cookie cutter, right? Everybody was court ordered to CMH regardless. But they didn't have a relationship with them. They had private insurance. I said, would you want to go to community mental health? He's like, well, no, why would I go there? I said, exactly. So what I'm trying to explain to you is you have all of these requirements for us that we should be tracking everyone, that we should know where everyone is getting services, That is an impossible task for us to adhere to all the court orders, because in our county, now mind you, we're a tri-county area, so we cover Clinton, Eaton, and Ingham. We have over 400 people on AOTs right now. 80 of those are privately insured. And I said to him, it's impossible. I am one person. How in the world do you expect us to monitor all of these people and ensure that they're getting the services that they need? And that's where the collaboration started. And he said, Miss Granger, I get it now. What can I do? And I said, well, we got to work together and come up with some type of funding. He said, you got it. And he went before the Board of Commissioners and helped to fund a position on the team. I started out with myself and one other person, and we've grown to 11 employees. So with that being said, where do you begin? It's in that way. You have to reach out to the prosecutor's office, the local courts, and you have to ask if you can sit down and chat with them. I recommend, though, that when you do that, that you have your top level administration do that. Our administration reached out with a letter saying that we would like to come to the table and collaborate with you and discuss the mental health code and how we can work together to serve those people in our community. And we got responses from that. And then what ended up happening is we did come together, and then that grew. And so I want to talk about that. Like, how do you do this? Well, we inquired up setting up a meeting in person. Of course, food helps, right? So we had a luncheon. We brought them all before the table, and we talked about, this is what our rules are. This is what our funding is. This is what we're able to do. And then they talked about, this is what they're able to do. And as we continued to do that, we were able to collaborate more, which then has developed into a really strong community partnership. And when I say that, we not only do we have a relationship with our local court, and we have a point person at our local court. So that person is my liaison. That is the only person my team connects with. We connect pretty much every single day. In addition, we also have a relationship with our prosecutor's office now. And our prosecutor has seen the value in this relationship and has now assigned us a liaison. So when we have difficult people, whether it be folks that they're seeing repeatedly committing crime, that have mental health issues, that they feel an AOT might benefit, the liaison and I are collaborating. We're talking through those cases. How can we support that person? In addition, I don't know if the rest of you are seeing this, but we in our area are seeing so many people that are coming and being found incompetent and not restorable, and the judge is ordering that an AOT be filed. And so we're working together with the prosecutor's office on that. Then that has led to, okay, what are we going to do? Now we've got our courts on board, we have a relationship. We're now working with our prosecutor's office, and we have a liaison. So now who else do we have to involve? Our police. So now we have police liaisons. So then now we have that partnership, right? So what we have in our local area is we have a lieutenant who is our liaison, but we also have police social workers. From that, we grew into, okay, what's next? And now what's next is we have our ERs involved. And so all of these folks come together on a regular basis. We try to have a quarterly meeting where we all come together and we talk about what we're facing out there. And I think what's been helpful is that by developing these partnerships, that the other community partners are finding that it isn't a refusal to do the work, right? I always say we all are doing the same, we all have the common goal. It is to get our individuals in the community with mental health concerns the treatment that they need. And it takes every single one of us. So how do we do that? Well, we have to do it by coming together and sitting at the table and hearing each other's perspective, and get to the past the point where I always like the blame game. This isn't the blame game, and I don't know if you guys experienced that, but it used to be, well, CMH didn't do this, or the police didn't do this, or the ER let them go. Okay, that may have happened, but what do we all do to come together? And so that's what we've done. With that being said, it has led to all of the community partners coming together and providing trainings together to the community, to, and to other partners to talk about each of the roles. And so what we've done moving forward, as I said, is we have scheduled regular meetings with our partners. We bring other partners on board as we feel it's important. So now we have our jail administration on board because as we know, there's several individuals with mental health issues that are in the jails. What do we do? Because once again, the jail's like, you got to get them out. They're not meant to be here. This is your problem. No, it's a we issue. And how do we do this? So now we bring them in. So every single year, our probate court and our team do the CIT training together to show that we are collaborative force. We also, each and every year, the probate court and my team, we do a training for the entire community. It's the ER doctors, it's other police entities, other prosecutors, and we do that yearly. And I will tell you that the attendance rate to those, we don't have enough room for it, is that there's so many people interested in that. So that's kind of how we have brought the partnership together. And so my takeaway, because I have to leave this open for questions for folks, is that the very first thing you need to do is reach out. You don't know where people stand until you reach out. Having your administration with a simple letter, like I said, hey, we'd like to reach out, see if we could have a meeting to discuss how we can partner and collaborate for the best of the community. And then continuing to foster that relationship by regular meetings, regular education. Also, one of the things that we did that was super helpful is we invited our judges to CMH. We invited the police. And they toured. They toured crisis services. They toured the case management teams. They saw what work was being done. In addition, our team will do ride-alongs with our police. Our prosecutor's office, we're attending courts. Like I said, we have the liaison. We're talking through these difficult cases. And I will tell you that the feedback that we're getting is amazing. It's making the work easier. As we know, this work is so tough, and that our population is growing and the need for AOT is growing. And so what do we do? And so it's that big thing of just coming together. If I can focus on nothing else but that, there is no magical tool. You may get some resistance, but it's just keep pushing and pushing. And as they see the benefits, you're going to get the buy-in. And so that's where we're at. And like I said, so right now we're at the point where we meet monthly with our ER and our police. We also are meeting quarterly with all of the prosecutors, the police, the jails, all of them. And then in addition, what we're also doing is, I don't know how many of you are, but we attend our hearings every single week. So anyone that is going to be on an AOT, whether it's just straight AOT, combined, they're in the hospital, we are present at the court hearings. We review the cases with the judge. We are completing the specific ATRs, the alternative treatment reports. We're reviewing the petitions and certs before they go before the judge. And we're trying to be as specific about the treatment, about the plans. We're attending all the deferral conferences. So then not only at the deferral conference, you're building those partnerships too that are going to go through, which ends up being partnership with a court-appointed attorney, which we only have one, so we're very fortunate, and he sees the work that's being done. We're then meeting with the hospital staff during these deferral conferences. We're meeting with the consumer, and then you've got CMH. And then all of us together are at these court hearings with the prosecutor, with the defense, with the judge, and we're collaborating during those hearings so that we're all on the same page And ultimately, what does that do if we're all on the same page? It benefits the consumer. And when the consumer sees that the services are being wrapped around and that we're all on the same page and we're all here for the common goal, they then become part of the partnership too. And they're more invested in wanting to engage in treatment. So with that being said, like I said, there's no magic pill, there's no magic tool. It's just continuing to foster that relationship. And so what I'd like to do is open it up to maybe specific questions that you have and how we might be able to address those within your own area. And then also, we will be sending out, I do have the PowerPoint that we use with our yearly meeting that we do in conjunction with the probate court that kind of gives you an idea of all the things that we go through in this yearly training. And also at the yearly training, not only do we involve the probate court, but our judge comes and speaks as well and helps with that training. So with that being said, I'd like to open it up to any specific questions that you may have that we can address today.
Thank you so much for your presentation, Christy, and for sharing with us a wealth of knowledge. As Christy said, if you have any questions, we open it to you all to address them or bring them forward. And Christy, as well as our wonderful panel here, would be open to answering those.
Hi, Christy. I have a question. I'm Melissa from Washtenaw. For your quarterly meetings, can you review again who you invite to those, and then what is your agenda for those meetings?
Yeah, so the quarterly meetings comprise of our behavioral health staff in the ER.
Okay.
They are probate judges, the prosecutor, our liaison at the prosecutor's office. We also often will invite the defense attorney, even though he's representing the consumer, he plays an integral part of what we're doing. And then, of course, our court team, and then the probate liaison. Sometimes we'll open it up depending on the topic. We'll open it up to like our jail administration, because for you guys, I think you also probably have a jail program. We have, our CMH staff embedded in our jail, and so we'll invite them. Our agendas vary depending on the hot topic for the month or for the quarter. For example, some of the things that we speak about, of course, is what's going well, what's not, what can we look to change, but also most recently we were having an issue with our emergency room staff when individuals were returning to the hospital, say on like a notification of non-compliance or demand. They were ignoring those orders and they were just letting the people go back out into the community. And what we were finding, for example, wasn't that they were ignoring it. Their Large Sparrow, as our local hospital is huge, the right people weren't getting the information. So that's when we came up with what we're going to do. So now we have a certain system where there's a certain code, like we have stickers, and these documents are in these envelopes with a bright sticker. And so we talk about things like that. How do we problem solve? And other things that we might do is we might talk about like the upcoming training, different things. We talk about the topic of NGRI sometimes because a lot of folks in our community and like even our local judges, they didn't understand the NGRI. They didn't, what the parameters were for that, and that they had to be on an order to still be on NGRI. So it's a wide variety of topics. And what we do is before the quarterly meeting, we'll suggest topics, and then the probate court takes the lead on that, and then we'll bring the topics forward. Hope that helps.
Thank you. That's very helpful.
Yes. Does anyone here have like some relationships with their probate court right now that are going well that they want to talk about and how they fostered that, or folks that are really struggling with their probate court and maybe some ideas we could bring forward? How many folks on here would say, even if you put it in the chat, that you have positive relationships right now with your probate court?
Christy, I don't know if you can see the chat. We have a question from Christine.
Okay, I can't see that right now.
Okay, she says, any suggestions for individuals on AOT orders that are continuously not following through? Does the court ever get involved with the enforcing of an AOT?
So yes, but that actually relies on the treatment provider. So it sounds like what you're asking is those folks that have established AOTs that are not coming in for treatment, not following medication recommendations, etc. And that is actually on the treatment provider to report to the court their non-compliance. So I don't know what county you're from, but I can give you an example of how we work when it comes to adhering to court orders. So we have a process in place where we receive all the orders. Obviously, we track those. We have someone who tracks privately insured folks and their compliance, and then we have someone that tracks folks that are already connected or will be connected to CMH and their compliance. That's where we bring in our community partners and use our police quite frequently, because if these folks are not complying, we're trying to do home visits. We're reaching out, trying to locate them. We'll bring the police in. That's a big part of our collaboration is we'll say, to our police group, listen, have you had any contact with John Doe? We haven't seen him. And oftentimes they're like, well, yeah, he's in the city jail. And then we'll collaborate that way. But then what we do, if all has failed, because we try many methods, because we all know that going back to the hospital these days, well, first of all, it's always very traumatic for the individual. Second of all, the lack of beds, the quick turnaround, we really try to avoid hospitalization. But if all else fails, what we're required to do is we, as the treatment provider, the judge has granted us the authority, which they can on the court order, that says if a psychiatrist feels like this, a return to the hospital. I'm not getting the right lingo because it's not right in front of me, but it's box 16 on the court order where it says a peace officer may take them into protective custody if a psychiatrist feels that it's warranted. That's what we do is then if that box is marked, we've tried all of these things, we have to fill out what's called a notification of non-compliance. And no, not every county does that. That's why I say we. With that notification and a copy of the order, the notification is signed by the treatment provider, which, before this is done, every treatment team has a psychiatrist assigned. So this has already been talked about with a psychiatrist. This notification gets completed and it gets taken to the local police department. And in turn, they will then go and try to take this person into protective custody. At that point, that's when the judge gets informed. The judge does not get informed of this non-compliance until that point because they've already given the authority in their order for them to be picked up. And our judge will say to us, listen, the order says they're supposed to comply, and I have directed you as the alternative treatment provider to make sure that they are doing so. And so that's how we work. That's where our workaround goes. So long story short, sorry, that was a bit much, is yes, our court is involved. They're involved from the beginning, and then we kind of take the lead, and then we go from there, if that helps.
So we've got a couple comments. Allison Mace says, yes, but our judges report that they are too busy to meet, making improvements difficult. And then Christine says, we do coordinate with the police, but sometimes we're trying to pick up the same individuals because they are not following through. And so the probate keeps pulling the order and they go to the ER again and the cycle just repeats. Not sure if there's a next step after the court, after that the court would be involved with.
Okay. So let's start first with the first one, which is our court is too busy. That's why I really recommend is if like our executive director got involved, and I think that and they have a way, right, of wording that or whatever, and really approaching the judge with, we understand and we know that this is difficult to fit into our daily schedule, but if we can get together moving forward, you'll see that it will take less time because our goal will be to have less people come before you, right? Because we can work together, we can ensure compliance or, work to ensure compliance. We can get these folks the treatment they need if we're all involved. And then, of course, you're just going to have those judges that just refuse. And I don't have a good answer for that. I mean, ours is just constantly, putting it out there that how this will benefit the community. The other thing that I recommend too is like the chief clerk or the chief probate register or administrator, they also often are a good resource. So maybe even reaching out to them saying, hey, what's a good way to approach the judge? We really think that this meeting would be beneficial or this collaboration. So they're often a good resource. So you could also try that. As far as the order, so I know there was several parts of that. So if we could kind of review that again. So you said these folks are going to the ER or the judge is pulling these. Can we repeat that question so that I answer?
Yeah, I'll just say it. So we get the non-compliance orders. We go because the provider pulled it. So we pick the individual up, we take them back to the ER. Usually, it might be like they don't meet criteria. You need to follow up with ISK. They're released and then they don't follow up. So then, or maybe they do, but they only make like 1 or 2 appointments, then they disappear. So the order gets pulled again and it just keeps cycling. So I was just wondering, is there any kind of backing from the court when that happens? Because I know providers get frustrated. I know police get frustrated. And the ER definitely gets frustrated.
They certainly do. And yes, that is a court order. That is the law. So the ER cannot discharge those. So that's first of all. So those are, so what I suggest is that really working with your ER, that if someone is in on a notification of noncompliance or a demand, the only reason I'm assuming that they're there is because that's where you may do your screenings or whatever. The ER, based an ONC and a demand, isn't always based on the criteria. Now here, I know, right? We have CMH dollars. We have to make sure that, these folks meet criteria for hospitalization. I get that. There are many folks out there that maybe they've been non-compliant, but mental status wise, they look good. It doesn't matter. This is a court order, and the court order says that they have to comply with medications and this, so they can, and it does meet criteria, if they are non-compliant with treatment, that they return to the hospital. And so that's where it gets tricky with the ERs. They're not there on the ONC or the demand to assess the appropriateness of psychiatric admission. They're simply there to do the medical clearance and to work with a pre-admission screening site to get them back to the hospital. And so working with your ERs on that and educating them on that. And that sometimes will stop the recidivism. Because you're right, they just get discharged and they just keep repeating and repeating. And that's where also the collaboration comes in with meeting with the police. This is another thing we do, is we meet every single month with our local police separately, and we talk about these cases where the recidivism is high or those challenging individuals. Like, for example, we have one today, she just calls 911 repeatedly, and our police, and she's on an AOT, and the police are like, just put her back in the hospital. But then we're like, listen, she's compliant with treatment. This is not a psychiatric issue for her right now. This is an attention thing. And so maybe we should look at, does she need to have some consequences for that? And so we come together and talk those things through. So that's how we get around it. But that is the really key thing about the ERs. When these folks are coming in on those orders, they cannot release them. I can't see the chat, guys, so if there's other questions.
There was
I
another
just,
question. Oh, go ahead, Autumn.
I was just saying, I just asked Paula if we answered her question, if she still, or if she still needed some more clarification, but Paula Copeland asked, how do you handle cases where a notification of non-compliance, the person has private insurance, and when screened at the ER, they do not demonstrate criteria for inpatient?
It's the exact same thing. It's a court order. And so what we do with our privately insured folks, so our team monitors those by so we work with several private providers, and so in order for an individual to work with a private provider that's court ordered, we have to confirm that the private provider knows that they're on the court order, that the private provider is willing to inform us of the non-compliance and to keep us updated. So the way in which we handle those ONCs is that those ONCs are being completed by us, because an ONC is the only document that can be done on hearsay under B on a notification non-compliance. It will say reports told to me. And then and because most of the court orders, I don't know for you guys, but for us, ours are pretty much cookie cutter, except for like the treatment part of it, like the meds, the injection. It's gonna say AOT under the assisted outpatient under the supervision of community mental health. It's pretty much. Sometimes it will say or private provider. So the onus for the compliance is still on CMH. So that's why we require for them to be seen by to continue with a private provider, that this private provider puts it in writing to us that they are willing to oversee this and to report that non-compliance. So then we'd still, once again, do that notification of non-compliance, and those folks go to the ER, and it's the same thing. It's a court order. Here's the non-compliance. We're saying they need to return, and we're the one responsible for adhering to this order.
Can I get a point of clarification on that last question as well, just in terms of, are we referring to somebody who is sent to the ER and the ER is provided with a copy of the order, or are we talking about a situation where the ER might not be aware that the individual is on an order?
My question was, you do the notification of non-compliance, the person ends up in the ER. We have these papers, they have private insurance, and they not meeting any other criteria for hospitalization, and the private insurance is not going to pay for another hospitalization. What do you do in that circumstance? Because they can't live in the ER.
Yeah.
Correct, but sometimes you wouldn't always know they can't based on how long they end up staying there. What I will say, and thank you for clarifying, I missed whether or not the paperwork showed up. One thing I'll say is, somebody who's worked in ERs for a long, long time, the ERs have virtually no knowledge of probate court law. It's staggering how little they know. And so it becomes, I think, an opportunity to build this relationship, to consider offering some type of like training, guidance, etc., what to do when these things happen. So that's one thing. I would say that more broadly, because I think that's a big weakness overall in our reliance on the ERs. The other thing I would note is that when in a situation like you described, the concern over criteria not being met probably comes down to, again, a lack of knowledge of either the probate law, right? So I still hear clinicians, physicians routinely say things like, well, they didn't say that they wanted to hurt themselves. It's like, well, thankfully we have way more latitude than an explicit statement being our only grounds. So I think that there are some definite opportunities there. Moreover, I think that, if the ERs have kind of a centralized point of contact with somebody on your AOT team that they can reach out to and kind of guide through this, that'll really give you the ability to make sure that they're aware of everything, especially because we know some of our clients, they can keep their symptoms relatively well hidden as well. Or at least they can be misleading enough that without any additional information, the ER might not ask the right questions. And they're certainly not going to know things like decompensation patterns, et cetera, that you can provide that will help them see, oh, here's where that criteria is met.
And just to kind of piggyback on that, Paula, you know, coming from the CMH world, like, you know, I hear that about the private insurance. And then what does that look like, right? Because consumers, they don't have those funds or whatever. And that's where the collaboration and partnership, like Scott talked about, comes in again. We're having a point person at the ER and providing that education, because the reality is, I don't know any other way to say it, it's a court order and there's no choice. And
But that doesn't mean a psych unit is obligated to take them, and they won't take them without payment.
Right.
I hear that, but I'm not running into psych units that aren't taking them on a notification of non-compliance, because it might take a while to find one, but we're obligated to return them to a facility if they're non-compliant, and the liability lies on us and the ER if they discharge them and something happens. And there's often times where folks aren't necessarily displaying symptoms, and I get it, right? Because there's got to be criteria, but it's a catch-22, because this is a legal document, a legal order in which a judge has ordered a psychiatrist. And here's the other thing I want to point out that might be helpful for psych units and the ER. The psychiatrist is the one returning them to the hospital, and how our court sees it too. The psychiatrist is the expert, not the ER. And so if the psychiatrist is saying this person is non-compliant and needs to return to a hospital, that's where this comes in. Now, it might be a short stay. You might be able to problem solve. Like if it does come to like 7 or 10 days in an ER, God knows it happens and we don't want that. Maybe getting involved with a private provider and yourselves and like coming together with a client and saying, listen, like we got to come up with something different. Because you're on this court order and you need to comply with this. We have no alternative. And that's the sad thing. We talked about this many times. It's frustrating because if someone's on an order, we only have one avenue if they're non-compliant, right? To return them to a hospital. And it doesn't always make sense because they're not decompensated. They're not. And honestly, I'll just be frank, it comes down to often to a liability in covering yourself. And it doesn't feel good because that's not what the business that we're in. We're in the business of providing treatment and helping people engage. But also we are under the jurisdiction of the court. And speaking from my end, the judge will put you in jail. And do you want to be put, and that's what I have to tell the ER, that's fine, you discharge them, you write that note, but then I'm going to share that with the judge because it's not on me. I did what I was supposed to do. And I know it sounds easy for me, right? Easier said than done. I do face these challenges every single day with the ER and often just want to hit my head up against a wall and say, I'm done, this is ridiculous, but it's the law.
And one other point on top of that, because it sounds like one of the bigger challenges is that, we might be returning somebody to, or wanting or getting that court order to return them to the hospital when they immediately become non-adherent to treatment, but before they have classic full symptom presentation. And so really the issue becomes, how do we articulate that they're meeting the medical necessity requirement so that like the reviewer for the private insurance is able to check their appropriate boxes. And this is where, in those cases where we are getting out front a lot, really one of the best ways to handle this is to have if you're getting a lot of pushback from that private insurance, do a doc-to-doc with the insurance company. So your psychiatrist can do a doc-to-doc with, their medical officer at the insurance company and more clearly articulate how this works. And usually that's going to overcome that barrier where a screener is saying, oh, you know, my algorithm didn't allow me to say, yes, we're going to approve this admission. But you also bring up an issue that, you know, is one that we've talked about with folks at the state a lot, and specifically requesting that we do some either internal rule changes with the Michigan Department of Community Health, or a legislative change to basically address where there's that gap. Because for AOT to achieve its full promise, we don't want to have to wait until somebody fully decompensates, wherein they would normally meet that criteria under the medical necessity piece. We want them to be able to get treatment and head that off. So this is, you know, this is where right now this might be, in fact, a bit more arduous for that, you know, especially that small percentage of people who are on private insurance that's not Medicare. The good news with Medicare is that there's really not a prior authorization, with the exception of some of the Medicare replacement plans. But doing that doc to doc, and then, you know, we're working on what we can with, you know, the state to try to get them to close that gap even further. I also think it's helpful when, you know, we're speaking with the people at the ED, whether it be the attending physician, a psych social worker, et cetera, that we really talk about what we are seeing currently, and how, again, if they're becoming non-adherent, typically there's a symptomatic reason behind that, and you can almost always get box C, and you just maybe need, you know, that do a little bit better job, I think, sometimes of articulating that, as well as articulating that just because there's no hallucinations or delusions doesn't mean there's not other psychotic features. And this is where, I know I've said this in many other meetings, but I think we need to do some better training overall so that people can identify and more readily, you know, communicate the myriad psychotic symptoms that would all meet that medical necessity criteria, from disorganized thinking to all of the negative symptoms.
I have a couple questions. So when someone returns to the ER for treatment on adherence on a pickup, like a demand for hearing pickup order, in the ER, does the psychiatrist then, are they required to fill out a clinical cert to get them involuntarily rehospitalized, or this court document suffices that? There does not have to be any petition or clinical cert to get them rehospitalized? Is that what I'm hearing?
Yeah, that's correct, Melissa. And so technically the psychiatrist in the ER wouldn't even necessarily, depending on their rules or policies in the ER, would not need to see them to return them to the hospital, because there wouldn't need that document, the cert would not be needed.
Okay. But there is discretion, and it is clear too that the goal is to exhaust all engagement efforts before making it to this place where you are doing that. I will say we have coordinated with RERs, because there's sometimes when the treatment on adherence is an injection, right? They haven't gotten their injection. And so we don't necessarily want them to be rehospitalized because they haven't gotten their injection. But what we have been doing is, so we coordinate with our ER, like medical director, and we let them know, like, hey, we really need this person to get an injection. If we had them picked up, like, when would be the best time to take them there, right? Because our ER is like, please don't just drop people off. Call us first if there's no acute needs, because we might be full and we don't want you to hear if we're super full. And they want to make sure that we have exhausted all those options. You know, they get mad at us when we bring people there and we haven't even attempted to see them, or our prescribers, like their prescriber hasn't weighed in, and everyone's on the same page that if this person isn't picked up and given treatment in the next week or two, they will very much decompensate, and it will be they will be at risk to the community. So we've had a lot of those conversations, and that has gone really well, you know, because sometimes it's like, well, do we have the injection? Do you need to bring it? You know, can we, because they ultimately want to convince them to have the injection while they're still in the ER and avoid an actual hospitalization, because there are cons to that, right? Like, because of hospital bed, placement and wait times, and, do we want the person to have the bed that's seriously decompensating and is in a full psychotic episode versus someone who's not at the moment, but is not complying with an AOT, right? There's a lot of factors, I think, when you go down the road and picking them up in the ER and you're talking about all of that. So it's complicated.
I think you hit the nail on the head. It is complicated, and yes, that is the whole focus, and why, like today, we're talking about this, is it being able to build those partnerships and collaboration, and you see how important that is so that you can do other problem solving, because we all agree we desperately need those beds, and we have some really acute folks out there, and so it is it's everything. And so it is exhausting. And so, yes, I never say, oh, they missed one appointment. I talk to our treatment teams about that. I'm not saying if you're on an AOT, you missed one appointment, you're back. I'm saying, okay, now you've missed 2 and 3 appointments. We've called you, we've done a home visit, we've involved all the, and you still aren't, you're going to be at risk. And so then we're going to do that. So absolutely exhausting all of those. For sure. And coming up, sometimes some really unique ways, right? And ways that we can get people into treatment. I know it sounds, ours is food. I don't know about you guys, but when we're doing our home visits, we've even had the police say, hey, you come in with us, you get, come to CMH for your appointment today, man. Looks like you could use a good meal. They're stopping and they're getting them a burger. And it's really, and that's what the purpose of AOT is, right? It's to get people engaged, to see the benefits of treatment. The whole purpose is so we're not having to hospitalize everyone. We're looking at other mechanisms and ways. And so, yeah, it definitely is complicated. So that's why I put up my last slide. Like, we all it's coming together is the beginning, staying together as a group is the progress, and then working together is the success. And I think if we take nothing but that away, Henry Ford said that's where we're at in the AOT world, is bringing all our partners together, because if we all work together, we're going to have success. And then ultimately the consumer benefits, right? We all know it's tough out there, and I don't know that psych hospitals are where folks want to be these days, or have ever wanted to be, but it's tough out there, and we're hearing stories, right? And if we can avoid those and that recidivism and that trauma, then I think we're successful.
Absolutely. Thank you so much, Christy. We appreciate you for taking the time to address some of the questions that we had, as well as questions that were posted in the chat. So if we don't have any further outstanding questions, or if anyone would like to go ahead in these final minutes before we end, ask Christy another question, we'll definitely take that. If not, then we can go ahead and conclude here today. I'll leave the floor open for anyone else that would like to go ahead and pose that question or questions. All righty, so thank you all again. We appreciate you for attending today, and extremely making this a robust space for learning and education as well. So please do not hesitate to reach out to us if you have any further or additional questions. And as always, we definitely encourage you to attend the office hours with Dr. Scott Smith if you have any further questions that you would like to address. But if not, thank you again. We hope you have a good rest of your day. And the next time we're scheduled to meet in this space is Friday, April 25th at 11 a.m. So I hope you all have a wonderful weekend.